Hi, I'm attorney Ben Haynes. I'm the founding partner at the law firm of Haynes and DePaz. Today I want to talk about the timeline that an owner has to make a claim for their surplus funds. I'm not talking about a subordinate lien holder. I'm talking about an owner's claim in Florida to claim surplus funds and how much time do they have. The main deadline in Florida that everyone talks about is 60 days from the sale, that any type of claim has to be made within that amount of time. It is actually only for subordinate lien holders. If you read the statute 45.032 and .033, it elaborates on how much time an owner has. Now, it doesn't necessarily state that the owner has to make it within 60 days. A subordinate lien holder has to make it within 60 days. But what the statute does state is, at least for now, if an owner doesn't make a claim within 60 days, then essentially on the 61st day, the court is supposed to designate a trustee or a third-party company to go and find this owner and make a claim for the surplus funds. Now, it doesn't usually happen that way because the court's not necessarily monitoring these cases and saying on the 61st day. I've seen it even be over 6 to 7, maybe even 9 months before a court does that. Now, once the trustee is appointed, and these trustees are these third-party companies who are not lawyers, most of the time they don't even find the person. So the issue that I want to bring up today is this, that an owner needs to make a claim for the surplus funds, generally speaking, within a year of the certificate of disbursements. And this is why. If a claim for the surplus funds is not made within that year, what can happen is the surplus funds can be sent to the state and the case can be closed. And I have seen it happen a couple of times here in Florida because an owner took too long. Now, it doesn't necessarily mean it's automatic, that the court's going to just send your funds a year and a day after. But for homeowners, don't take a chance. Now, I know this may not mean too much to a lot of people, but because most owners, they know that there's a surplus because these third-party companies hound them. Don't hire them, by the way. They're nightmares. And they're saying, I'm going to get my money fast. And you should. You should always try to. This is for people who maybe are an heir who didn't know that there's a surplus, or an owner who just didn't understand how it all worked. If you don't understand or you have a surplus case, I always advise, before you do anything, contact a experienced Florida surplus lawyer. I handle surplus cases all over the state of Florida. I give free consultations on the phone. If you decide you want to hire our services, then we take them on contingency, which means I only get paid if I win and also collect the funds for the owner or the heir. And so, again, it's the timelines in surplus funds are very important. It's everything. It's all, there's substantive law, obviously, but procedure in surplus cases dictates whether or not you're going to collect your full amount, whether you're going to collect it in a timely manner, or whether you're not going to collect it at all. And I highly advise that an owner contact a surplus lawyer in Florida to discuss what their options are. My name is Ben Haynes. I'm the Florida surplus lawyer in Florida, and this is a blog to help owners understand the timeline more in order for them to collect their funds. Until next time.